Hey guys, it's attorney Bianca Jordan from brazenlegal.com. Today's video is on an immigration development that affects certain beneficiaries of green card holders. As always, this video is for general purposes only. It is not legal advice, but if you do want legal advice specific to your situation, you can visit brazenlegal.com/contact. So generally speaking, in order to get a green card, you have to have a petition filed for you by a certain relative. So if you are a U.S. citizen, you can file a green card application for a spouse, a parent, a sibling, or children. If you have a green card yourself, you can only petition for unmarried children or your spouse. Typically, if you are an immediate relative of a U.S. citizen, and an immediate relative for immigration purposes is a spouse, parent, or child under the age of 21, also unmarried. So if you are a married child under 21, or if you are unmarried over 21, or if you are a sibling of a U.S. citizen, you are not an immediate relative, and so you would need to consular process. You cannot adjust your status to get a green card. So you would have to leave the United States to get your green card. Similarly, if you are the relative of a green card holder, you cannot adjust your status. You would have to leave the United States in order to get your green card. However, for July 2019 and August 2019, certain relatives of green card holders are able to adjust their status while in the United States, meaning that these relatives can get their green card in the United States without leaving the United States. So the relatives that can do this for July 2019 and August 2019 are spouses of green card holders and unmarried children under 21 of green card holders. So this is for people that have not yet applied. So if you are a green card holder and you have already filed an application for a relative, a spouse that maybe is not in the United States, or a child who is not in the United States, if you have already filed this application, it's already pending, this does not apply to you. So unfortunately, that relative will still need to wait for their notification from the National Visa Center before they can continue on with the process. This person cannot just contact the National Visa Center or go to the embassy and say that they want to apply for their green card now. This change really only impacts people that have not yet had an application filed for them. So if you are a green card holder and you are married, and your spouse is currently in the United States with you, and you have not yet filed an application for this spouse, they may be able to apply now, and they may be able to adjust their status without having to leave the country to get their green card. Not everybody qualifies for this, so there are certain exceptions, and before you go and just try to do this on your own, you really should speak with an immigration attorney that can walk you through the process, that can determine whether or not your relative really does qualify, and then you can do the application. What ends up happening sometimes is people might jump the gun and apply for a green card, and they don't know that, because their relative maybe had some time in the United States where they weren't documented, now they consular process and they have to leave the country to get their green card. Leaving the country will then trigger something called unlawful presence. And so that person, depending on how long they were out of status for, when they leave the United States, they won't be able to come back for 3 to 10 years. So before you go and do this, it's really important that you speak with an immigration attorney that can walk you through the process to determine whether or not your relative really can adjust their status. And if it ends up being that your relative must leave the United States, then the attorney can also review that case to see if maybe an inadmissibility waiver is required for your relative. So again, this change is for July 2019 and August 2019, people that are in the F2A category. So those are spouses and children of green card holders. They may apply to get a green card in the United States. But again, before you do so, please speak with an immigration attorney to confirm that you do qualify, and then the attorney can handle your case and walk you through the process successfully. I hope you found this video helpful. Please please visit brazenlegal.com to learn more about me, my law firm, and how I can help you with your immigration needs. Thanks for watching.